let's kind of take this in reverse. So the first question is relatively easy when you say, can statutory notice be bypassed? So you have to have notice of board meetings and annual meetings. And those are controlled by the governing documents, and they're also controlled by the Florida statutes. There is nothing that's happened with the COVID-19, in my opinion, that would, a board would be able to say, we just couldn't get out notice, but we had to have the meeting anyway, because there are processes in place for emergency meetings, and the notice requirements are certainly less than what they would be under a regular meeting for a board, and also for an annual meeting if you had some kind of special members meeting, I should say, not annual meeting, which is also a members meeting. But so there's certain kind of lessening of the notice requirements, but to say, well, we're just going to hold a meeting and we're not going to notice it, I think anything that was actually done at that meeting would be invalidated and would not be enforceable. To me, that's pretty clear cut. You could argue against it, but that's one of the more clear-cut things that I can opine about in regard to COVID-19. Now, having said that, the question is that the first part of the question in regard to having meetings, the most of the governing documents that are out there, I know this is generalizing, but most of the ones that are out there talk about the initial board meeting. They talk about having to have an annual meeting. So you have that once a year, but there really aren't other requirements for the board to meet for a particular time frame. In other words, monthly or quarterly or biannually. That's in the majority of the cases. And then with the member meetings, you have the annual meeting, and you're typically not required to do anything else unless there's a petition made from 10% of the membership to have a special meeting of the members, or if a board member says we're going to have a special meeting because of X, Y, and Z, and then they can also call a special meeting of the members. But typically, that's not required under the statute or the governing documents. If you do have governing documents that say, okay, this is the initial meeting of the board when the property is first developed, and we're going to have board members at least quarterly or monthly, are you required to do that under the governing documents? Yeah, if it says that, you're required to do it. Is there anything in the statute that would allow you to have forgiveness based upon that? Well, only in the items that I talked about before where you have emergency situations. Now, under COVID-19, could you say, well, we're just not going to have those meetings? Maybe. And when I say you can't, that means, will there be ramifications if you don't? Because certainly the board could say, we're just not going to hold it. And then you would have to either go to court or go to the state and request some kind of relief if the board just kind of refuses to do that. I've seen some boards that have said, well, because of this, we're just not going to hold any meetings at all. And the problem is that you and I are doing this interview right now over Zoom. There's all kinds of video conference services, and they're, most of them are free. The ones that charge are usually for big groups, and if you do, that's minimal. So certainly you could have conferences like that. You have phone conferences that could be set up. You could make some accommodations as opposed to just saying, we're just not going to meet anymore. So I think it would be difficult to justify. Now, if there are other factors that I haven't considered or I haven't seen so far during the pandemic, then that may change my opinion of it. But right now, I think that you would be obligated if the governing documents said you should hold those. You obviously have to notice those properly. Would you have to hold those in person? Probably not. If you're you know, fearful that social distancing won't be kept into place, and you don't have enough space to allow for adequate social distancing with people there, you could make other kind of accommodations. So you just don't say, we're not going to do business anymore, even though the governing documents say we have to. So I think that would be tough for a board of directors to justify.